Yes, we can hear you.
Okay.
All right, so should we go ahead and start the round?
Hi. Hi, everyone. Yes, please start the round.
Great.
Can I request the judges and the participants to open their cameras and mics? Radha Krishnan, can you please open your camera? So from the judges, I believe Radha Krishnan is here, Branham Paul, and yes, Radha Krishnan and Branham Paul. So please feel free to start the proceedings.
كريستين انت بقى في حوار سام.
Hello.
Hello.
Can you hear me?
Hello,
Yes, can you
yes,
hear me?
yes, we can hear you now.
All right. All right. So, are the teams ready?
Yes,
Yes,
if the
you're
part
ready.
The team from the University of Calabar, are you ready?
Yes, we are.
What about the team from Middlesex University?
Yes, we're ready.
All right. I think we can proceed now. I'll call on the team. I'll call on the team from University of Benin to tell us how they wish to use their time.
Oh, thank you very much. Your honors, I would like to use 18 minutes for my arguments and reserve 5 minutes for my rebuttal, while my
No,
co-counsel would
please.
like
First
to
of all,
use.
introduce your first. Wait. Kindly introduce yourself. Then, if you are the speaker one, you tell us the time you are going to use. Then the speaker two, you also tell me the time the speaker two is going to use.
All right. My apologies. Hello, my name is Richard Felix Uche. I am the senior claimant.
Please spell the name. Spell the name.
Okay, Richard is spelled Richard.
All right.
Felix Uche is spelled Felix hyphen UCHE.
Good.
That is my last name.
CHE.
Yes, UCHE, Uche. That
All
is
right.
my last name.
What about the speaker two?
Okay, the speaker two is Kekayo Joseph.
Spell.
Kekayo is spelled Kekayo.
Kekey. K. Spell it again.
Kekayo.
All right. Keka, your word.
Um, Joseph. Joseph is spelled Joseph.
All right. So what's the time allotted?
Her last name is Odum. Sorry, Joseph is her middle name. Her last name
So
is
what's the
Odum.
time allotted?
Odum. Okay, she would like to use 17 minutes for her arguments and reserve 5 minutes for her sorry rebuttal.
Who is the speaker one?
I am
You are using how many
Felix.
minutes?
18 and
18.
5.
Speaker 2 is using how many?
17 and 5.
All right. Please, I would like to confirm from my other judges if you've heard what the team from the University of Calabar just said.
Yes, I'm fine with that.
Thank you, sir. Please, I'd like to confirm from the other judge. All right, I think we are fine. So please, the team from the Middlesex University, could you tell us your time allocation?
Yes. I'm Zahra Al Marhoon. I'm senior counsel. My name
Please,
is
could you spell your name?
yes,
Speaker one, please spell your name.
yes. My name is spelled as Zahra, and then ALMARHOO.
Please, could you reiterate? Thank you.
Yes, yes. It's Zahra, Zahra, and then Al Marhoon, ALMARHOON.
All right. What about speaker two?
Yes, speaker two is Kabisha Shuling. It's spelled as Kabisha is KABISHA, and then Shuling SHULING.
All right. What was the time allocation? Speaker one has a minute. What's the time for speaker one? And
For
also, what's the
speaker
time for
one,
speaker two?
pardon me. For speaker one, it's 17 minutes for submissions, and then 5 minutes for rebuttals. And speaker two, 17 minutes for submission, 5 minutes for rebuttal.
All right. I would like to confirm if my brother judges are able to hear what the team from Middlesex University just said.
Yes, I see this fine. So I think we can proceed now.
All right. All right. Before we proceed, please, for the purpose of accuracy, if you can have it typed in the chat, your names, just your names, that's from both teams, University of Calabar and also from the Middlesex University, we will appreciate. I think it will aid in getting appropriately the correct spelling. Thank you. And we can proceed now. I believe both teams are aware of how the proceeding is going to go on. Senior claimant counsel first, then the senior defendant counsel second. That's defense to the claim. Thereafter, we can have the rebuttals. Is that clear? All right. So the senior claimant counsel can now proceed. And I also wish to inform you that I'll be taking cognizance of the time. So counsel can proceed. Thanks.
Thank you very much, Your Honor. Your Honors, my name is Richard Felix Uche. I am the legal representative of the claimants in this suit. Your Honors, I will address this court on the first issue, which is the claim, and my junior claimant will address this court on the second issue, which is the defense to the counterclaim. Now, Your Honors, a brief summary of the case before this court will highlight that the claimant, Ms. Artemis Ashretea, purchased a spaceflight ticket by paying a certain amount of money to the defendant, Solar Dream Incorporation, in consideration for her participation in a spaceflight retreat. And per the agreement, our client was supposed to comply with certain obligations under the contract. Now, the defendants, in dereliction of some of their obligations under the contract, disabled our client from being able to enjoy the benefits of the retreat which he had paid for, thus necessitating the suit before this court. Your Honors, if you have a clear understanding of the brief summary of the facts highlighted, may I proceed?
Yes, you can proceed.
Thank you very much, Your Honor. Your Honor, on the first issue, which is the claim on Solar Dream's liability to Ms. Ashretea in both torts and for breach of contracts. Now, it is our submission that the defendant is liable to the claimant both in torts and for breach of contract. And our submission will be put forward on two grounds, which are, first, Solar Dream is liable to the claimant for negligence, and second, Solar Dream breached its contractual obligations under the agreement. Your Honors, may I proceed to outline our pleadings?
Yeah.
Sorry, Your Honors, may I proceed to outline our pleadings?
Yes, please proceed.
Thank you very
Please
much, Your
proceed.
Honors. Thank you very much, Your Honors. On the first ground, which is Solar Dream is liable to the claimant for negligence. Now, Your Honors, the tort of negligence is established in Article 17, Sub 1 of the DIFC Law of Obligations. And this article provides that the defendant is liable in negligence to a claimant if and to the extent that, first, the defendant owed the duty of care to the claimant. Second, the defendant breached that duty of care to the claimant. Third, the defendant's act or omission in his breach of that duty of care caused loss to the claimant. Now, Your Honors, paragraph 7 of the Moot facts clearly depicts that the defendant owed the duty of care to the claimant upon her purchase of the space flight ticket. And this duty naturally arises out of the contractual relationship between both parties, where the defendant was supposed to provide a safe and secure space flight experience for our clients, and our clients paid valuable money as consideration for same. Your Honors, this duty of care also arises from the common law principle of occupier's liability, which expounds that the defendant, as occupiers of the premise, owes a duty to the client, to our client, the claimant, as occupiers of the premises, to the end that our client is supposed to remain reasonably safe for the entire duration as a visitor to their premises. Now, Your Honors, this court in Faisal Babu Muakat versus Expresso Telecom Group Limited, citations 2023, DIFC Court of First Instance 008, stated that the existence of a duty of care depends on the criteria as set out in Article 18, Sub 1 of the DIFC Law of Obligations. Now, this article provides that the defendant at all times had a duty of care if it is reasonably foreseeable that the defendant's acts or omissions could cause harm to the claimant. Your Honors, it is indeed not out of place to state that the natural and foreseeable consequence of embarking on a space flight. Yes, I can, Your Honor.
Could you tell us briefly the fact of that case?
Sorry, Your Honor, the facts of which case?
The case you just cited.
The case I just cited.
Yes, you cited the case.
Okay, thank you very much, Your Honor. Your Honor, briefly, we do not have the exact facts of the case, but this case was a case where the DIFC Court of First Instance attempted to establish the existence of a duty of care between different contractual parties. Now, Your Honor, we only took the court's decision in the case as was relevant to our case before the courts. Therefore, we do not have the full facts of the case. We outlined that in our... Oh, thank you very much, Your Honors. Your Honors, for further reference, we outlined the fact in our skeleton arguments. Thank you very much, Your Honor. Now, Your Honor, before your question came in, I was addressing this court on how there exists a duty of care between the defendant and our client, the claimant. And I was addressing this court on the fact that the case so stated highlights that there's an existence of a duty of care where it is reasonably foreseeable that the defendant's actions could cause harm to the claimant. Your Honor, like I was stating, it is indeed not out of place to state that the reasonable consequence, the reasonable and foreseeable consequence of embarking on a spaceflight experience without first obtaining and verifying that the medical status of all the passengers to this flight experience has been cleared as fit for such purpose is the heightened risk of undetected diseases like the Vulcan virus spreading among passengers and crew of that space flight, which in the instance of this case is exactly what happened, as highlighted by paragraph 13 of the Moot facts. Therefore, Your Honors, we submit that the defendants had a duty of care to the claimant as it was reasonably foreseeable that their actions toward the claimant could cause loss to the claimant. On the second element of negligence, which is the breach of the duty of care, for the defendant to have breached their duty of care towards the claimant, they must have fallen short of the standards expected of them as space flight operators, having regard to the probability and likely seriousness of any loss that may be caused to the claimant as expressed by Article 21 sub 1 of the DIFC Law of Obligations. Your Honors, the defendant's actions in first, not conducting proper COVID tests on the claimant and all other passengers of the space flight before lumping them into one quarantine facility was a breach of their duty of care towards the claimant. As the Moot problem indicates in paragraph 9, that our clients only started experiencing severe headaches during the second week of the quarantine exercise. Now, Your Honors, interestingly, this falls in line with medical statistics, which states that individuals start showing symptoms of the Vulcan virus after coming into contact with carriers within 5 to 10 days. Your Honors, our client started experiencing severe headaches during the second week of the quarantine exercise, and medical statistics states that it only takes 5 to 10 days for individuals who come in contact to become asymptomatic, thus allowing us to submit that it is reasonably foreseeable or it is reasonable that our client contracted the virus during this exercise. Second, the defendant, in refusing to obtain the PCR test results of passengers before greenlighting takeoff for the space yoga mat, knowing fully well that the PCR test is a more accurate way of determining if the presence of the Vulcan virus is in the passengers, also breached their duty of care towards the claimant, as this was a flagrant disregard of all medical and safety protocols as regarding space flight, as the standard of care imposed on air transport companies is one of the highest standards of vigilance and precaution. Therefore, their actions constitute a breach of their duty of care towards the claimant. Your Honors, in the estate of William Madden et al. Versus Southwest Airlines, citations CO 121 CV 60672, the Maryland District Court of the United States observed that in situations where employees were not effectively screened for diseases, the employers were to be liable to the employees as they owed them a duty to enforce precaution. Now, Your Honors, in conclusion, satisfying the third element of the duty of care and the breach of which is negligence, the breach by the defendant caused loss to the claimant in this case. Your Honors, it is our submission that the defendant's negligence caused our client to not just contract the Vulcan virus, jeopardizing her health and incurring medical costs, but it also rendered her unable to participate in the Stars Align Retreats activities, which of course, Your Honors, was a fundamental aspect of the contract between both parties and for which our client had paid considerable money for. Therefore, Your Honors, in light of all these arguments, we so submit that the defendant owed the duty of care to the claimant to enforce proper medical safety protocols. They breached that duty of care and it caused loss to our clients. On the second ground, which is that Solar Dream breached its contractual obligations as set out in the agreement. Your Honors, it is our submission that the defendant's actions towards the claimant constituted a non-performance of their contractual obligations towards the claimant. Now, Article 77 of the DIFC contract law states that non-performance is the failure by a party to perform any one or more of their obligations under the contract, including defective performance or late performance. Your Honors, General laws of contracts are guided by certain elements, amongst which consideration is one of. Now, Your Honors, under the terms of the contract, our client was to participate in the Stars Align retreats, where she would record videos of her space yoga sessions and upload same to her YouTube channel. This was made known to the defendant in the negotiation of the agreement between both parties. And the defendant, in turn, and our client also paid a considerable amount of $7.5 million. Now, the defendant, in turn, was supposed to ensure that our client benefited from the activities of the space retreat as their own consideration under the contract between both parties. Your Honors, it is very important to highlight again that this formed a fundamental aspect of the contract between both parties, and where our client was unable to get any value for her money whatsoever, we therefore hold that the defendant's actions constituted a non-performance of their obligations under the agreement between both parties. Again, Your Honors, there are certain clauses within the agreement which mandate the defendant to comply with certain regulations. Now, one of such is Clause 5, which highlights the defendant's obligation to ensure proper medical evaluation of the passengers in line with industry best standards and practices. Your Honors, we have been able to show in the previous arguments for our ground one that they did not comply with this particular clause, showing how they breached their duty to ensure all the passengers, including our clients, was declared fit for space travel. Again, Clause 7.1 mandates the defendant's strict compliance with certain requirements concerning space flight operator safety protocols. For instance, Article 44.2 of the United States Federal Aviation Administration Regulation on Spaceflight Safety provides that spaceflight participants must undergo a medical consultation proximate to their flights to assess their medical fitness for space travel, and this must be conducted by a physician with training and experience in aerospace medicine. Now, Your Honors, an interrogation of the case before this court shows that the medical nurse who was contracted to perform the cursory medical examination on our client and all other passengers was contracted last minute. Your Honors, this shows that the defendants had no clear and obvious plan to comply with the directives of this regulation, as the nurse was only contracted last minute, where the COVID test should have been conducted earlier, or possibly by a medical professional that had been designated for those tests. Also, Your Honors, the defendant was not in compliance with this regulation by greenlighting takeoff for the space yoga mats without first assessing the medical results of all the passengers, including the claimants. Now, Your Honors, it is our submission that the basis for any medical test is for the results to be received and assessed in consideration of the purpose for the test. Your Honors, where the defendants initiated the test, but they did not have the patience to wait for those test results in order to assess them in consideration of the space travel, it can as well be said that there was no test done because the results were not assessed. Furthermore, Article 6, Sub 1G of the Human Spaceflight Activities Regulation of the United Arab Emirates 2022 require space operators to implement security and safety measures to prevent any participants of human space flights from exposing the crew or general public to danger. Your Honors, I think it is pretty evident by the facts of this case that the defendants were not in compliance, as the dereliction of their obligations exposed not just our clients and the other passengers of the space yoga mats to danger, but the entire humanity entirely aboard the floating Haven space station. Your Honors, it is our submission that the defendants' deficient safety measures exposed the claimants and all other people aboard that space station to danger. Thus, they should be held liable for breach of contract by not complying with this obligation. Conclusively, in the case of Liberty versus Lance Real Estate Broker and others, the DIFC Small Claims Tribunal held that where there exists an event making performance impossible, restitution to the original status should be achieved. Your Honors, we have been able to show this court that the defendant is liable in tort for breach of their duty of care towards the claimant, and multiple instances where the defendant was not in compliance with regulations that was made mandatory by provisions of the agreement, particularly Clause 7, being in breach of their contractual obligations. Therefore, these instances of breach have caused potential loss and actual losses to our clients, some of which we have frontloaded to the court in the chat box, the rest of which we would like to outline before this court. Your Honors, if I have your permission, may I proceed? Sorry, Your Honors, do I have your permission to proceed and outline some of the actual damages and potential damages caused by the defendant's actions to the claimant?
Branham has
Okay.
Yeah, please go.
Thank you very much, Your Honors. First, the defendant's breach caused the inability of our clients to enjoy the full benefits of the Stars Align retreat, which he had purchased for a whopping sum of about $10 million, had paid 7.5 and was to pay 2.5. Therefore, they deprived her of value for her money, which was lost to her. Again, the loss of projected earnings and income, which our client was poised to make as a successful YouTuber by being the first YouTuber to upload a space travel vlog. As Your Honor, a YouTuber with our client's following of about 27.3 million subscribers would make something around the ranges of $4,000 to $5,000 per 1 million subscribers, thereby translating into hundreds of millions lost by our clients. Again, the medical costs incurred by our clients by her totally avoidable contraction of the Vulcan virus. And last but not least, the non-economic damages suffered by our clients for the emotional distress and reputational harm caused to our clients by not just the contraction of the virus, but by our clients' failure to follow through and deliver on a widely advertised series of space yoga videos that she had previously told her subscribers that she was going to upload. Therefore, Your Honors, the claimant is justified in seeking damages to the tune of $15 million for actual losses and potential losses due to the severity of breach of the defendants, as their breach goes to the root of the contract between both parties. And Your Honor, we urge this honorable courts to award the sum of $15 million in damages and to resolve this issue in favor of the claimants. With this, Your Honors, the claimant concludes his pleadings. Thank you very much, Your Honors.
Hi, Mr. Kikai. I have just one question for you. I want to ask if the claimant has suffered headache for 5 years, and this is a fact that we all know. I just want to ask, how do you explain not disclosing this health condition to the defendant, despite the fact that it's one of the symptoms of the diffuse disease? So I just need to hear your explanation regarding this point.
Thank you very much, Your Honor. Your Honor, in response to your question, the non-disclosure of our clients about her headaches must be understood within contemplation of the agreement between both parties. Now, clause 5.2 of the contract states that the claimant was under a duty to disclose any medical condition which would impact her ability to participate in the space flight that the defendant was in the process of launching. Now, Your Honors, where the facts have clearly stated that our client has had these headaches for 5 years and her physical capabilities were not hindered in any way, again, she had passed the initial physical evaluation by the defendant 2 days after she purchased the tickets. Your Honor, it is reasonable to conclude that our client simply did not believe that her headaches, which she did not know were a medical condition because she was felt to have been diagnosed for the past 5 years, was something that she was to disclose to the defendants. Your Honor, has my response satisfied your concern?
Yes, thank you.
Thank you very much, Your Honor.
Is Mr. Branham is here? Would he proceed?
Shall the defense proceed?
Hi, Mohammed.
Hi.
I believe Branham has been logged out, so I think we should start out with Zara's as well.
Okay, I think I'm satisfied now with the claimant's thoughts. So we can proceed with the defendant.
Yes, I think Zara as a defendant can start
Yes,
off.
please, Ms. Zahra, you can proceed, please.
Yes. May it please the court, my name is Zahra Al-Marhoun, and I am senior counsel for the defendant Solar Dream Incorporated in this case. I'll be assisted by my learned junior, Ms. Kavisha Shuling. Your Honor, we submit that the key issue in this claim is whether Solar Dream Incorporated is liable to Ms. Artemis Asrotia by way of committing a tort of negligence and by way of breaching their contract. Your Honor, I'll be addressing the defense to this claim, for which I will be making two key submissions. Firstly, that my client cannot be found liable in tort for negligence as they had not breached their duty of care by taking reasonable steps to mitigate the risk. Secondly, and alternatively, that my client's performance was in no breach of the contract signed by both parties in accordance with the national and international regulations specified in clauses 7.1 and 7.2 of the Spaceflight Agreement. Your Honor, may I proceed with my first submission?
Yes, please proceed.
My first submission regards the notion of negligence in tort. For that, I would like to draw your attention, Your Honor, to the DIFC Law Number 5 of 2005, titled The Law of Obligations. You may find this on page 24 of the court bundle. Article 17, which may be found on page 27 of the court bundle, states that a defendant is liable in negligence to a claimant if the defendant owes a duty of care to the claimant and breaches that duty, causing loss to the claimant. The first requirement of a duty of care is set out in Article 18, subsection 1 of the Law of Obligations, which may be found in page 28 of the court bundle. It states that a defendant owes a duty of care to a claimant where the defendant's actions may reasonably and foreseeably cause loss to the claimant, and where there is a relationship of proximity between the defendant and the claimant, and where it is just, fair, and reasonable to enforce such a duty. It is reasoned that my client's actions during the flight could cause loss to the claimant, as they, Solar Dream, are the operator of the flight and Ms. Asrutia is a passenger. Additionally, there is proximity between my client and Ms. Asrutia as they are both parties to the same contract. So counsel for the defendant thus does not dispute this relationship. However, Your Honor, if you do find that there is a duty of care owed by the defendant to the claimant, we submit that the defendant was not in breach of that duty as they had not fallen below the standard of care expected of them. This is laid out in Article 21, subsection 1 of the Law of Obligations, which you may find in page 30 of the court bundle. It states that in order to establish a breach of duty of care, the claimant must show that a defendant failed to exercise reasonable care to avoid causing loss to the claimant. And reasonable care is defined in Article 21, subsection 2, which you may find on page 30 as well, as the care which a person of ordinary regard and skill performing the same activities as the defendant would exercise. In the present case, the defendant's duty was to ensure safety aboard the flight for all of the passengers. For that reason, there is the requirement of medical evaluations, which is included in Section 5 of the Spaceflight Agreement. Additionally, there is Section 7 of the Spaceflight Agreement, which details the safety protocols which the defendant adheres themselves to. Performance of this responsibility was seen when my client had Ms. Asrutia undergo several medical evaluations and exams, which I will now list for the benefit of the court. First, there was a declaration form provided to the claimant wherein she signed that she was not aware of any medical conditions or symptoms that may affect her journey. Second, there was a medical history log given to her to fill out and list all ailments that she currently is or was suffering from. Third, she underwent a physical exam and other tests by a specialist doctor from Solar Dream's medical staff to test her fitness levels. I will test these exams. I will list these exams for you. There was A group of tests conducted by a doctor which involve a cardiovascular assessment, including an electrodiagram. There was a spirometry test, a vision test, a general psychological health questionnaire, a blood pressure test, and additionally, blood and urine samples were taken. Other tests were conducted by a nurse, which are as follows. There was a physical examination, the passenger's temperature was taken. Additionally, there was a blood pressure test, a lateral flow test, and a PCR test. In addition to all of that, Ms. Asrutia was required to quarantine herself for 2 weeks prior to the launch of the flight. This is in accordance with Solar Dream's safety protocols. Your Honor, these were all precautions and protocols that my client undertook to ensure safety for all of the passengers. It was not at all something that could be described as the bare minimum. And reasonable care had been taken by the client in regards to safety, because what else could they have done? There is no case in the DIFC's jurisdiction, of my knowledge, that concerns the degree of measures that should be taken by defendants to avoid causing harm to the claimant. And so for that, I would like to draw your attention, Your Honor, to a common law case of the United Kingdom, Latimer and AEC Limited, which was decided in 1953 and reported in the first volume of appeal cases, page 643. You may find this case on page 10 of the court bundle. Your Honor, do you need the facts of this case?
No, thank you. You could proceed without facts.
Then I shall proceed. In this case, the court held that the employer did not have to take such extreme measures to avoid a risk of harm. In fact, the employer only has to take what is reasonably expected of them. Lord Asquith, in page 12 of the court bundle, paragraph 8, line 5, sentence commencing with "what evidence," states that in that case, the degree of risk was not sufficient to warrant an extreme measure to avoid it. As such, the obligation upon a defendant is to minimize the risk of harm by taking reasonable steps. There is no duty upon the defendant to exact extreme measures for that cause. So if the court were to take this judgment into consideration, we submit that the defendant had done more than what was reasonably expected to minimize the risk of medical emergencies and harm to the passengers. This is due to the plethora of medical examinations which the claimant had to undergo. As such, my client had taken reasonable care and cannot be said to have fallen below the standard expected of them. Additionally, there is the element of causation, which is stated in Article 10, subsection 1 of the Law of Obligations, which you may find on page 24 of the court bundle. To establish liability under this law, a claimant must show that, but for the defendant's conduct, he would not have suffered loss, and that the defendant's conduct was a substantial cause of his loss. However, Article 11 on the same page of the court bundle finds that where the defendant's conduct causes loss to the claimant, the defendant is not responsible for the loss if there was a supervening event, which made it so that the defendant's conduct is no longer an operative cause, meaning the defendant's conduct is no longer acting upon the claimant. Counsel for the defendant submits that the defendant's conduct of launching the flight before receiving the PCR test results is not a but-for cause for the claimant's loss. For in fact, there was an intervening act, following Article 11, which is the fact that the claimant purposely avoided disclosing her chronic headaches and later did not inform the defendant of the new wave of headaches prior to the launch. How could my client be expected to act upon knowledge which they did not possess at the time? Ms. Astrutia's actions constituted an intervening act because the defendant simply could not have expected her to refrain from disclosing her full medical history as they had both agreed upon in the contract. For the basis of all contracts at the end of the day is the promise to fulfill obligations, and an action that defies that principle is surely unexpected. Had the defendant known of the chronic headaches, perhaps more care would have been taken in ensuring Miss Astratia's medical fitness, as it may have been cause for worry. And evidence of that is the fact that the claimant's own reasoning for non-disclosure of her headaches is that she feared that it would prevent her from participating in the flight. Your Honor, if it was truly a trivial, inconsequential medical condition, there would be no reason for her to hide it or fear such a result. We submit that that is the ultimate cause for her loss, which arose out of her inability to participate in the retreat due to the outbreak of COVID aboard the flight, and the PCR tests indicated that she had been the source of the virus. As such, counsel for the defendant submits that the defendant is not liable in tort due to not reaching the duty of care to the claimant and the claimant's failure to establish a continuous chain of causation between the defendant's actions and her loss. Your Honor, may I proceed in my second submission?
Yes, please proceed.
My second submission regards the rights and duties upon the defendant as agreed upon in the spaceflight agreement. Section 7 of the Spaceflight Agreement, titled Spaceflight Operator Safety Protocols, details the obligations upon the defendant to ensure compliance with national and international standards and safety procedures. My learned colleagues claimed that my client had breached the obligations upon them per the contract. We dispute this and would like to draw Your Honor's attention to one of the laws applicable under the agreement. Article 6 of the Human Spaceflight Activities Regulations of the United Arab Emirates 2022, which you may find on page 42 of the court bundle. This provision details a myriad of obligations upon a spaceflight operator to their passengers. These obligations are such as informing them of possible known and unknown risks, training them, installing adequate equipment, and ensuring their safety from dangerous objects. The defendant's actions, as seen so far and stated in the case facts and listed previously, had complied with each of these requirements. Article 6 does not detail an obligation upon the operator to protect passengers from diseases or other such medical conditions, which is the claimant's point of contention here. That is Solar Dream's failure to provide necessary protocols that would have prevented the outbreak of COVID. Further regulations were decided upon in Clause 7.2 of the agreement, which states that my client will apply and confirm to the following. Firstly, the latest version of the United States Federal Aviation Administration's recommended practices for human spaceflight occupant safety. And secondly, Parts 7, 8, and 12 of the Space Industry Regulations 2022 of England and Wales. As for the first regulation, which you may find on page 31 of the court bundle, Section 3.4.3 of the Recommended Practices for Human Spaceflight Occupant Safety states that prior to the flight, operators should enforce procedures such as a quarantine to prevent the spread of infectious diseases amongst the crew. Your Honor, this was done prior to the flight, as stated by the case facts, and there is subsequently no breach of that contractual obligation on behalf of my client. In fact, this was also the immediate course of action taken by Solar Dream upon knowledge of Ms. Astratia's positive COVID result. As for the second regulation, Section 72, subsection C of the Space Industry Regulations 2022, which you may find in page 32 of the court bundle, confers the obligation on the operator of the flight to ensure that no person takes part in spaceflight activities, either as a crew member or a passenger, if that person is not medically fit to fly. The defendant acted upon this duty by taking reasonable measures and performing several medical evaluations, distributing declaration forms and medical history logs. This was all done to ensure full knowledge of the passenger's medical state and subsequently be able to decide who to send to space. And we have listed previously the many medical exams that were given by Solar Dream to Ms. Astratia. Your Honor, these were the obligations that were set out by the regulations chosen in the spaceflight agreement, which was signed by both parties. My client trusted Ms. Aswatia to uphold her end of the agreement and cannot be reasonably expected to act upon a risk they were not privy to. Solar Dream followed all the requirements set out by each regulatory document to the best of their knowledge. And as such, counsel for the defendant submits that it was the claimant's failure to inform the defendant of her chronic headaches that prevented them from performing their duties to a fuller, more adequate extent. The defendant's safety protocols are in no breach of their contractual duties because they meet the requirements set out by the different governmental regulations and recommendations within the context of the information that was provided to them. Once more, had they known of the chronic headaches, perhaps a different course of action would have been taken. Unless I may assist you further, Your Honor, that concludes my submissions.
Well, thank you, Ms. Zahra, for your submissions. And I also have a question to you. Despite the fact that there was first medical exams that all the travelers had, they were then quarantined for, I think, 2 weeks, during which the claimant caught such a disease. So you are explaining that the defendant has made its a duty of care uh, in all the the proceedings of this matter, but in the last time regarding the PCR test, they didn't make or they didn't have the results due to the intervention of the claimant by not disclosing uh, its health status for headache and all of this. So what if we have assumed, or let's assume that any of the other travelers have caught this disease during the 2 weeks after examining them in the first test? How would you know, as the defendant and the counsel of the defendant, how would you know without having the results of the PCR? So how could we assume that the defendant has made its a duty of care and obliged with it if they didn't have the results for the PCR tests, because there were 2 weeks of quarantine without exams and without the medical exams. So the PCR test, I think, there was very important and crucial before traveling and before having this trip.
Yes, so I believe that we do see the importance of the PCR test now due to the gift of hindsight. However, at the time, uh, my client did not launch the flight of their own whims. In fact, they had referred to the opinion of a specialized nurse who did recommend to launch the flight, only referring to the lateral flow tests, claiming that they were sufficient enough. The lateral flow tests also tested for COVID. However, they are less accurate, perhaps. However, it is because Solar Dream depended on that professional opinion that they ended up launching the flight. I believe that it was not Solar Dream's fault in this case because it was the opinion of a professional. They could not simply know better as they are not a medical body themselves. I hope my answer has clarified your question.
Thank you. However, had this professional advised that please launch the flight without having the PCR test, is there any declaration from him or from her regarding this matter? That you can proceed with the flight and launch the flight without having the PCR results?
Unfortunately, I do not have a written declaration. However, in reference to the case facts, the nurse at the time had advised Solar Dream to launch the flight, only referring to the lateral flow test. So at the current moment, we only have the facts of the case to rely on.
Thank you. Okay, any of the judges have any question for the defendant?
No questions from my side, Mohammed.
Okay, thank you. I think now we can proceed with the counterclaim. Mr. Branham, any questions?
No questions from my end.
Perfect.
I think we should have the rebuttals now. Can anyone hear me?
Yes.
We are able to
All
hear
right.
you.
Yeah. Okay. All right. Thank you very much. Considering the moot court rules, that's in respect to the oral, I was considering we can proceed to the rebuttals now. That's the senior claimant counsel can have his rebuttal. Then we have a short rebuttal from the senior defendant counsel.
Unfortunately, we don't see them.
The senior claimant counsel, are you present? All right. I think we can proceed to what as I think we can proceed to the counterclaim.
Okay. Thank you very much, Your Honor. I apologize for our brief exit from the
Well,
court.
hello. Can you hear,
We were
counsel?
logged
Can you
out.
hear me? I think you were
Yes,
cut off
yes,
for
Your Honor.
some minutes or seconds.
Yes, Your Honor. I was about to apologize for leaving the court. The platform logged us out on our previous system, so we had to quickly log back in on this system. As you can see, the background is different now, unlike the
All
real
right, that's
background we had.
understandable. Please proceed. Proceed with your rebuttal.
Thank you very much, Your Honor. Your Honor, we'd like to express our gratitude for giving us another opportunity to address this court and rebut the arguments put forward by the defendant counsel. Now, Your Honors, counsel for the
Hope you
defendant.
recall you have 5 minutes.
Yes, yes, I do, Your Honor.
All right.
Thank you very much, Your Honor. Your Honor, counsel for the defendant alleged that the defendant did not breach his duty of care to the claimant, stating that our client's non-disclosure was an intervening act which disrupted causation. However, it is our submission that our client's non-disclosure did not disrupt causation in the circumstances of this case. Your Honor, counsel for the defendant stated that they were under no obligation to go to extraordinary miles in order to ensure that, stating that the tests that they had conducted were sufficient enough for launch. However, we would like to draw the attention of this court to the fact that paragraph 11 of the Moot fact states that in the months preceding space flight, there was news of a new COVID variant, which is the Vulcan virus. Now, Your Honors, given the volatile nature of outer space, and the potential for pre-existing medical conditions to be exacerbated by outer space environments, we believe that for a global pandemic to not be reasonably foreseen by the defendant and to conduct tests in order to detect the presence of that virus in all passengers of the spaceflight was indeed a breach of their duty of care. Your Honors, our non-disclosure did not constitute an intervening act because at the time when they started testing for the COVID virus, the flight was set to depart on the same day. Instead of waiting for the results of that test, they decided to take off without obtaining those results. Your Honor, from the moment where the test was conducted to take off, our client's non-disclosure played no part in the test conducted by the defendant. As such, it does not constitute an intervening act. So we submit that the causation was there. The cause of the cancellation of the retreat was the contraction of the virus, and the contraction of the virus was because the defendant lacked proper medical protocols to prevent this contraction. Your Honors, the defendants also stated that they were able to implement protocols in compliance with their obligations under Clause 7. However, I would like to draw the attention of this court to the fact that the first protocol should have been prevention, and where the defendants were unable to prevent the widespread of this disease, then of course, it's either there were no protocols implemented or their protocols were so deficient that it was properly without utility. Your Honor, we would like to state that the defendant also was not in compliance with their obligation to provide medical tests, as the aim of these tests is to detect diseases. Now, where the test conducted by the defendant was not able to detect a global pandemic, which was everywhere in the news, we so submit that they were not in compliance with their obligations, as these are the kinds of tests that they should be on the lookout for. Your Honors, counsel for the defendant also stated that they now see the importance of the PCR test and their failure to and their actions in departing without obtaining these results. However, it is our submission that our client has already suffered damages by their failure to see this importance, and as such, our client has to be compensated. Their failure to reasonably foresee that these tests were crucial and could cause an outbreak in outer space is no fault of ours, and our client deserves compensation to that effect. Your Honors, we would like to reiterate that the defendants owed a duty of care, not just from the contractual obligations imposed on them, but also via the principle of occupier's liability, as the court stated in Witt versus Raycon, that an occupier is liable to ensure the safety of all visitors that come within their premises for the entire duration of their stay on their premises. Conclusively, Your Honors, the defendant's breach of duty of care and breach of contract have caused considerable harm to the claimant, which we have outlined in our pleadings. Thus, we urge this honorable court to discountenance any and all defenses put up by defense counsels and uphold the claim of the claimants, awarding the claimants the sum of $15 million in damages, as well as resolving this issue in our favor. Thank you very much, Your Honors. With this, the claimants conclude their case before the court.
Senior Defendant Counsel, you can proceed with your short rebuttal if you have any.
Thank you, Your Honor. Counsel for the claimant claims that non-disclosure was not an intervening act, as the defendant should have gone to extraordinary lengths to prevent the spread of disease. However, we submit that that is an unreasonable measure, as they are a business after all. It cannot be expected of them to go over and beyond when they had met the necessary requirements. We have aimed, or we strived to persuade the court using the common law case of Latimer and AEC to express that really the only measure that should be taken by a defendant is to minimize the risk of harm rather than completely prevent it by taking an extraordinary measure. This is why there are safety nets, if you will, which were placed by the contract, such as the declaration forms, the medical logs, to ensure that the defendant is aware of any and all medical conditions that the claimant could have. At the end of the day, the defendant could not have prevented the contraction of the virus itself. This is because Miss Asrutia had been traveling prior to reaching Dubai, where the flight was supposed to launch. All of this traveling from one city to another could have very likely exposed her to the virus, and she might have contracted it there. According to the timeline, as the virus takes around 5 to 10 days to really appear as a symptom, she could have well contracted it before reaching Dubai. This is the only logical conclusion. And it is exactly because of the consistent traveling and the risk of some disease being contracted during that journey that there is a 2-week quarantine before the launch. It is during this quarantine where the claimant was expected to notify them of any changes. That is the purpose of the quarantine. It is to ensure that nobody has caught a disease and has been incubating in their body for that long. The medical staff and the medical examinations could not have tested a headache, as this is something that does not really have a medical evaluation for. The claimant was under the duty to disclose that. At the end of the day, this was a duty that was not met by the claimant. The damages that were caused were because she failed to disclose that information earlier. And this information is necessary because the knowledge of these headaches is important. Otherwise, why would Miss Asrutia hesitate and eventually refrain from disclosing that information. Her own reasoning was that it might affect her eligibility to participate, and the counsel for the defendant here ventures to corroborate that suspicion. Had she disclosed her headaches, chances are that my client would not have entered into the contract with her, completely avoiding this loss to the claimant. Or perhaps knowledge of her headaches would have placed her under closer surveillance, making it so once her COVID symptoms began showing, there would be closer inspection, there would be a sooner PCR test. My client would have, in that situation, taken earlier action, and we are confident of that fact. After all, it is Solar Dream's contractual obligation to ensure that all of its crew and passengers were medically fit for space travel. It would not venture to take shortcuts or cut corners in that aspect, as it would cause them great loss. We have no doubt that my client would have taken every measure to ensure that the issue of her headaches was properly and adequately addressed in the right time. This concludes my rebuttal.
All right, thank you very much. Big thanks to the Senior Claimant Counsel and also thanks to the Senior Defendant Counsel. In respect to the counterclaim, we now call on the counsel to please proceed.
Thank you, Your Honor. May I proceed?
Yes, please proceed. I think you have 17 minutes for for your
Yes,
submission.
Your Honor. Thank you. May it please the court, as you have heard, my name is Kavisha Shulin, and I am the junior counsel representing the defendant Solar Dream Incorporated for this case, which is Ms. Astrathia's liability to the defendant for breach of contract. Your Honor, as mentioned in the skeleton argument, which I believe is before you, I will be making two key submissions. Firstly, the claimant, Ms. Astrathia, has breached the agreement entered into on 13 December 2023, specifically under Clause 5, which focuses on medical evaluation. Secondly, the defendant is entitled to terminate the agreement due to fundamental non-performance and receive damages for the financial loss. Your Honor, may I proceed with the first submission?
Yes, please proceed.
Thank you, Your Honor. My first submission regards the breach of contract by the claimant. For that, Your Honor, I would like to draw your attention to Clause 5.2 of the agreement, which states that she declares and represents that, to the best of her knowledge, she is not aware of any medical conditions or symptoms of such that may affect her fitness to participate in the spaceflight. This is where Ms. Astrathia's first breach has occurred. Your Honor, according to the facts of the case, the claimant has been suffering from chronic headaches for 5 years, and the various doctors that she visited had not been able to cure her. Prior to the flight, she signed a declaration form that confirms that she was not aware of the existence of any of the symptoms of potential medical conditions. She was also given a medical history log to list any prior current ailments. However, the claimant chose not to mention her chronic headaches during this medical evaluation because she was afraid she would be disqualified for the retreat. That choice is a breach of Clause 5.2. Furthermore, Your Honor, there was a second breach performed by Ms. Astrathia, in which she failed to inform my client of a change in her medical condition before the launch of the flight, as mandated by Clause 5.3 of the agreement. During the week before the flight, the claimant suffered from a severe headache, which she described as unpleasant. However, she continued to stay silent and not inform anyone about this new headache. Your Honor, these headaches were later found to be COVID-19 symptoms, which spread to the rest of the passengers and resulted in the untimely return of the flight to Earth. Once again, the claimant failed to meet another contractual obligation. These actions constitute a non-performance of the contract, as defined by the DIFC Law Number 6 of 2004, titled Law of Contract. Your Honor, if I could guide you to page 23 of the court bundle. where Article 77 finds that the failure by a party to perform one or more of its contractual obligations, including defective or late performance, to be a non-performance of the contract. And this honorable court has found non-performance to be a breach of contract. Your Honor, allow me to guide you to the case of Hatay and Hansel, 2017, DIFC Small Claims Tribunal 083. Page 17, paragraph 25 of the court bundle. Your Honor, would you benefit with the facts of this case?
Proceed.
With the facts of the case, or shall I proceed with my submission?
You may proceed with the fact of the case, then proceed with your submission.
Thank you, Your Honor. The defendant in this case is a landlord who entered into a tenancy contract for a year with the claimant. Before settling in the premises, the claimant noticed a few issues in the maintenance of the apartment and its household appliances, all of which the defendant promised would be fixed before the claimant moved in. However, the defendant failed to commence with the maintenance, which forced the claimant to pay for all the fixtures himself, including further issues that were discovered later. The court found that the major maintenance was the sole responsibility of the defendant to address, pursuant to the tenancy contract between them, and the defendant was in breach due to that non-performance of that clause. Accordingly, Your Honor, Ms. Astrathia's previously discussed failure to act in accordance with the obligations conferred upon her by the agreement, which she signed, constitutes a breach of contract. However, Your Honor, counsel for the claimant may claim that Ms. Astrathia was in no breach due to non-performance of her contractual duty to inform of her headaches because she did not acknowledge her condition as significant enough to report. Counsel for the defendant submits that that is factually incorrect, according to the facts of the case, and that alternatively that decision in itself is a breach of contract. First, it cannot be said that Ms. Astrathia did not acknowledge the possible impact that her headaches might have had, because in reference to the case facts, she chose to not disclose this condition due to the fear of being disqualified. This proves that she was aware of the result of telling the truth. She chose to be dishonest so she can achieve her goal to shoot a video for her YouTube channel and be the first YouTuber to upload a space travel vlog. Your Honor, my clients placed their trust in the claimant, but she came to the court with unclean hands. And then secondly, Your Honor, clause 5.2 of the spaceflight agreement further states that the passenger acknowledges the importance of providing accurate and complete information during the medical evaluation. This is an agreement which the claimant read and signed on her own volition. Thus, it became her duty and responsibility towards the defendant to abide by the agreement. She cannot claim not to have acknowledged its importance, as she was not coerced into this agreement. Sorry. Her cooperation would have ultimately been to her benefit, for as my learned senior previously established to you, Your Honor, had Miss Astrathia disclosed her medical condition, this situation may not have arose in the first place. As such, the counsel for the defendant submits that the claimant failed to perform her obligations under the agreement, which constitutes a clear breach of contract. Your Honor, may I proceed with my second submission? Your Honor, may I proceed with my second submission?
Yes, please proceed.
Thank you, Your Honor. My second submission regards the termination of the agreement and the relevant damages that the defendant would be entitled to. For that, Your Honor, I would like to bring your attention to page 23 of the court bundle, where Article 86, Section 1 of the DIFC Law Number 6 of 2004, titled Law of Contract, which states that a party may terminate the contract where the failure of the other party to perform an obligation under the contract amounts to a fundamental non-performance. Your Honor, on that same page of the court bundle, Article 86, Section 2 provides several instances to determine whether a failure to perform an obligation amounts to a fundamental non-performance. I shall submit 3 instances that satisfies the court. Firstly, Article 86, Section 2, subsection A states that it should be considered whether the non-performance substantially deprives the aggrieved party of what it was entitled to expect under the contract. As per the case in hand, the defendants expect the participants to be physically fit to travel in space, which is evident from the spaceflight agreement and the number of measures taken to clarify the medical state of the claimant. Therefore, it is vital for her to be honest about her medical history. Secondly, Article 86, Section 2, subsection B states that strict compliance with the obligation, which has not been performed, is of essence under the contract. Your Honor, to confirm how strict compliance is of essence, I would like to draw your attention to page 43 of the court bundle, where Article 6J of Regulation on Human Spaceflight Activities of the United Arab Emirates Space Agency 2022 mentions that an operator has an obligation towards the participants of the human spaceflight to make sure evidence has been provided to prove that the participants are fit to participate. Your Honor, to understand the context of Article 6, Article 1, which could be found in page 40 of the court bundle, defines an operator as a person who carries out space activities, space support flight activities, high-altitude activities, space data management and dissemination activities, or any other relevant activities subjected to this law. Under the similar article, human spaceflight is defined as any spaceflight using a space object with any member of the spaceflight crew or any of the participants of the spaceflight or both. Accordingly, as an operator, my client is obligated, as per spaceflight regulations, to provide evidence that the claimant is fit to participate. Therefore, this proves that strict compliance with medical evaluation, including disclosure of medical history or current symptoms of a condition, is of essence under the agreement. Lastly, Article 86, Section 2, subsection C, states that the non-performance should be intentional or reckless. Your Honor, the claimant chose to withhold the information about her chronic headaches because, for the sole reason that she was afraid that she would not be allowed to participate in the retreat. Therefore, this determines that the non-performance by the claimant was intentional. Considering the three instances that were satisfied under Article 86, Section 2, this concludes that the claimant's failure to perform an obligation has amounted to a fundamental non-performance, and as a result, according to Article 86, Section 1, this allows the defendant to terminate the agreement. Your Honor, in regard to the damages suffered, my client faced a significant reputational loss as a result of the early cancellation of the retreat, which led to reservations for future space retreats being cancelled by the passengers. For that, Your Honor, I would like to draw your attention to page 23 of the court bundle, where Article 109 of the DIFC Law No. 6 of 2004, titled The Law of Contract, states that any non-performance confers the aggrieved party a right to damages, either exclusively or in conjunction with any other remedies except where the non-performance is excused under this law. Moreover, on that same page of the court bundle, Article 86, Section 2 of the DIFC Law No. 6 of 2004 states that termination of a contract does not preclude a claim for damages for non-performance. Your Honor, accordingly, the counsel for the defendant submits that the defendant was the aggrieved party to the previously established breach of contract by the claimant, therefore it confers a right to damages. However, since there were no cases reported in this honorable court that I am aware of regarding awarding damages for reputational loss due to breach of contract, I would like to draw references to two UK cases. Your Honor, allow me to guide you to page 9 of the court bundle to the case Forminal Laboratories Limited and British Artide Plastics Limited, which was reported in the second volume of All England Law Reports in 1941 at page 393. Your Honor, would you benefit from the facts of this case? Your Honor, would you benefit from the facts of this case?
No, please proceed without the facts. Thank you.
Thank you, Your Honor. In this case, it was held that the plaintiffs were not entitled to include their damages, a claim for loss, as they had not proved that it was within the contemplation of the parties and they had not presented any evidence of pecuniary loss. However, Your Honor, if you could look at page 9 of the court bundle in the last line of paragraph 3, Appellate Justice stated that if pecuniary loss can be established, the mere fact that pecuniary loss is brought about by the loss of a reputation caused by the breach of contract is not sufficient to preclude the plaintiffs from recovering in respect of that pecuniary loss. Moreover, Your Honor, allow me to also guide you to page 14 of the court bundle to the case of Malik and Bank of Credit and Commerce International SA, which was reported in the appeal cases in 1998 at page 20, where the House of Lords awarded damages to the injured reputation due to a breach of contract. Your Honor, would you benefit from the facts of this case?
No, thank you. Please proceed.
Thank you, Your Honor. The plaintiffs were able to claim for damages in this case for this injury to their reputation and consequent difficulties in finding new employment, allegedly caused by the bank conducting a dishonest and corrupt business. Your Honor, if you could look at page 15, paragraph 5, line 3, Lord Nichols stated that if a breach of contract gives rise to financial loss, which on ordinary principles would be recoverable as damages for breach of contract, those damages do not cease to be recoverable because they also be recoverable in defamation action. Your Honor, in this case, Lord Stein also mentioned in page 18 of the court bundle, page 16 of the court bundle, line 18 of paragraph 6, that no lord said that in breach of contract cases, compensation for loss of reputation can never be awarded, or that it can only be awarded in cases falling in certain defined categories. Accordingly, the counsel for the defendant submits that Ms. Astrothea's breach resulted in the early cancellation of the retreat due to COVID-19. And as a consequence, my client faced reputational losses where multiple passengers cancelled their reservations for future space retreats. Your Honor, this is the financial loss resulted due to the claimant's breach. Therefore, instead of reputational loss, the defendant can recover damages for this financial loss. In conclusion, the claimant, Ms. Astrothea, breached both Clause 5.2 and 5.3 by not disclosing her chronic headaches during the initial medical evaluation and during the second week where she had a severe headache. This has resulted in a non-compliance of the obligation under the agreement. Moreover, since the claimant's failure to perform an obligation has amounted to a fundamental non-performance of the agreement, as per the law, the defendant is allowed to terminate the agreement. Finally, the defendant also has the right to claim damages, which is the financial loss resulted due to the consequence of the reputational loss caused by the claimant's breach. Your Honor, unless there are no further questions, this concludes the case of the defendant.
Okay, many thanks, Ms. Kabisha. I think we can proceed now with the claimant to defense against the counterclaim. The junior counsel claimant is present.
Yes, please proceed.
Thank you, Your Honor. Yes, Your Honor, I am present.
Yes, please, you can proceed.
Start. May I proceed?
Yes, please.
May it please this honorable court. Your Honors, my name is Kekaya Joseph Odum, and I am the legal representative to Ms. Artemis Astrothea for the defense to the counterclaim. Your Honor, it's a submission that my client followed all protocols and guidelines provided by the counterclaimant, Solar Dream Incorporated, in the contract, and her actions did not contribute to the contract's breach as claimed by the counterclaimant. Your Honor, these submissions would be expatiated under 4 key points. Your Honor, the first is payment and compliance with contractual obligations. Your Honor, the second is the doctrine of frustration. Your Honor, the third is impossibility of performance. and the fourth is contributory negligence. May I proceed, Your Honor? Your Honor, may I proceed with my submissions?
Yes, please.
Okay. Your Honors, I proceed with my submissions. Your Honors, to my first submission, my client fully complied with her contractual obligation brought by the agreement signed before. She cannot be liable for the breach of contract as claimed by the counterclaimant Solargym Incorporated. Your Honors, my client acted in accordance with her contractual obligations set forth in the contract by making the required payment of $7.5 million on time for the space flight ticket. Your Honor, my client made this payment with the promising intent to complete the remaining $2.5 million for the ticket. Your Honor, Your Honors, my client also submitted herself to the medical evaluations, physical examinations, and varieties of tests conducted by Solargym Incorporated. Flowing from the circumstances of this case, Your Honor, my client also adhered to the pre-flight requirements by quarantining with the rest of the passengers as stipulated by the counterclaimant. Your Honor, my client also submitted herself to the COVID-19 test conducted by Solargym Incorporated, and she also waited for the results of this test. Your Honor, my client only proceeded for departure when she got authorization to do so by the counterclaimant. Your Honor, the premature termination of the space flight and the inadequate safety measures that led my client to contract the COVID-19 signify the counterclaimant's failure to provide the contracted services. Your Honor, in conclusion, the failure of this, the failure of the counterclaimant to absolve my client of the liability as the breach of the contract originated solely from the counterclaimant's inability to fulfill their primary contractual obligations. Your Honor, on my second submission on the doctrine of frustration, we submit that the frustration of the contract was not as a result of the alleged negligence by my client. Your Honor, the doctrine of frustration, which is a common law principle, states that if an unforeseeable event occurs after the contract is formed, which radically changes the nature of the contract can be frustrated. Your Honor, Article 82 introduces a general concept of force majeure into the law of the DIFC. Your Honor, a party is excused from non-performance if they can prove that such non-performance was due to an impediment beyond their control. Your Honors, as stipulated in this case, it should be noted that my client strictly adhered to the contract and there's no negligence on her part. She upheld her end of the obligation. Your Honors, it's crucial to highlight the counterclaimant's materiality in this situation as their breaches caused the frustration of the contract. Your Honor, the counterclaimant failed to provide a safe and complete spaceflight experience due to the outbreak of the COVID-19 virus, which forced the early cancellation and the return of the retreat and the return back to Earth to avoid worsening of the situation. Your Honors, in understanding my justification of frustration, I would like to give a reference in an example. Your Honor, if I paid $50,000 for a meet and greet with a celebrity and the celebrity died before the meet and greet, will it be fair that I should be forced to still pay this $50,000 for the meet and greet? Your Honor, in this situation, the doctrine of frustration will intervene. Your Honor, given from my example, I would like to state the case of in the case of Taylor versus Caldwell, 1863, 3B and S 826, Blackburn J. Blackburn J held that there was an implied term in the contract and the consent for would exist at the time of the contract. Your Honor, from the peculiar circumstances of the case, it is an implied, we can say that it's an implied term in the contract that the space flight experience would exist at the time of the contract. Your Honor, the space flight experience was made impossible due to the outbreak of the COVID-19 virus, which was as a result of the counterclaimant's inability to inadequate safety measures and protocols. Your Honors, on my third argument on the impossibility of performance, we humbly submit that the impossibility of performance as a result of the counterclaimant, there was impossibility of performance as a result of the counterclaimant inadequate safety protocols. Your Honor, Your Honors, the impossibility of performance is a direct result of the counterclaimant's actions, and it's essential to highlight the impact of these actions on my client's ability to fulfill her obligations. Your Honor, the external circumstances specifically related to the health risks, which was not adequately managed by the counter-claimant, rendered it impossible for my client to fulfill her role in content creating during the flight. Your Honor, the actions of the inadequate safety protocols, failure to provide a space flight experience, which was not paid, which was the primary reason for the contract, has rendered my client's ability to fulfill her obligations. You know, the common law doctrine of impossibility of performance, also known as frustration on purpose, holds that if performance of a contract becomes impossible due to the actions of a counterparty, the aggrieved party is relieved from their obligations under the contract. In the case of Fibrosa SA versus Fairbairn Lawson Combe Babor, 1942, two all ER 122, 1943, is the interpretation of the contractual obligations, frustration of the contract was prevalent. Therefore, Your Honours, from these facts given above, we can ascertain that the result of the counterclaimers' inability to fulfill their safety protocols resulted in the impossibility of performance by my client. Therefore, my client should be relieved from the contract. Lastly, Your Honor, on the fourth argument, we submit that my client in no way contributed to the non-fulfillment of the contract. Your Honor, it is evident that my client fulfilled all her contractual obligations to the contract, and any failure to fulfill Your Honor, the allegations on non-performance is based on the misguided belief of her of her failure to disclose her chronic headaches. Your Honor, my client had no duty to disclose her chronic headaches because she could not. Your Honor, my client had no duty to disclose her chronic headaches, but because she did not believe that the chronic headaches in any way constituted of a medical condition that will make that will contribute to her inability to participate in the space flight. Your Honor, in the circumstances of the case, I would like to clarify the misunderstood provisions of clause 5.2 of the agreement, of the space flight agreement. Your Honor, the space flight agreement, this clause stated that all passengers declare and represent that to the best of their knowledge and belief, they are not aware in the space flight. Your Honor, it's important to understand that why these chronic headaches can be a standalone medical condition, they may not, they do not indicate an underlying medical issue. Your Honor, the International Headache Society, a global authority in the discussions of headaches, defines chronic daily headaches as 15 or more headache episodes per month for at least 3 months. Your Honor, chronic headaches is not a classification of is not an official class in the International Classification of Headache Disorders. You know, it's crucial to recognize that my client has had this chronic headache for the past 5 years, and this headache has not in any way restricted my client from participating in any social and physical activities, therefore failing to fall within the contemplated clause of 5, the contemplation of clause 5.2 of the agreement. Your Honor, from the circumstances of this case, it is also seen that the counterclaimant, Solargene Incorporated, conducted a series of tests, both physical and medical tests, on my client, which she gracefully passed, therefore proving once and for all that these chronic headaches were not a medical condition that will hinder her participation in the space flight experience as provided under clause 5.2 of the agreement. Your Honor, it's also established in law that when someone has suffered a wrong, there should be a corresponding remedy to this wrong. Your Honor, this Your Honor, this common law doctrine, this common law doctrine is captured under the Latin maxim of ibi jus ibi remedium. Your Honor, this principle is extended to breach of contract, and when there is a breach of contract, there is a remedy at hand for this breach. Your Honor, the most common remedy being damages. Your Honor, in the case of as stated by Part B, in the case of Robinson versus Harman, it stated that in the rule of common law that when a party sustains a loss as a result of breach of contract, he is so, as far as money can do it, to be placed in the same situation with respect to damages as if the contract has been performed. You know, in awarding damages, we should take caution to ensure that the innocent party should be returned to the position they would have been if the breach did not occur, and the defaulting party is
Kamsi, are you there? Can anyone hear me?
Yes, we can.
All right, all right. I think she got off. We may have to. She has about 5 minutes left. So I think we'll stay put.
so the alleged damage by my client is Jesus. Your Honor, I'm so sorry for the pause, Your Honor. I was logged out, Your Honor. Your Honor, I was addressing this court on the remoteness of breach of the contract. Your Honor, may I proceed?
Yes, but Council, kindly be reminded that you have about 4 minutes left.
Your Honor, may I proceed, Your Honor?
Can you hear me, Council? Can anyone hear me? All right, all right.
Your Honor, do you hear me?
All right, can you hear me?
Your Honor, do you hear me?
All right, Council,
Yes, Your Honor.
can you
I'm
hear me?
sorry, I
Please
was
proceed.
logged off from the site, Your Honor.
Proceed. You have about 2 minutes left.
Yes,
Your time has been
okay,
counting.
Your Honors, Your Honors, I was addressing this court on the remoteness to damages. I was addressing this court that the direct result of the breach was as the result of the counterclaimant's failure to implement proper medical protocols to prevent the widespread. Your Honors, I have no reason why the site will continuously log me off. Your Honors, I would like to request 2 minutes to conclude my submissions. Your Honors, may I proceed?
You have 2 minutes. Just round off. You have 2 minutes. Your time ordinarily has expired, but we're giving you 2 minutes to round off.
Your Honors, court. May I proceed?
Yes, I said you can proceed. You have 2 minutes to round off. Your time ordinarily has expired.
Your
Are you there?
Honors, do I have the attention of this court?
Can anyone hear me, please? All right. Thank you. Please, my brother judges, what may we do in this instance?
I believe she got disconnected, so I think that the counsels for the defendant should proceed. Hello, Ms. Richard.
All right. Thank you very much.
Your Honors, may I proceed? Do I have the attention of this court?
Yes, you can proceed for 2 minutes.
Yes, you can proceed. Well, you have 2 minutes to round off.
Yes, because I think you have some troubleshoots with your connection. So once you are stable, you can proceed for 2 minutes.
Your Honors, may I proceed? Your Honors, may I proceed? Do I have the attention of this court?
Yes, please proceed. If you can hear us, please proceed.
Okay, Your Honor, I would like to request 2 minutes to conclude my submissions.
Yes, you have these 2 minutes. Please proceed.
Your Honors, in my conclusion, my client's actions and behavior in relation to the contract with the counterclaimant, Solar Dream Incorporated, demonstrate her adherence to the agreed terms of her and her intent to fulfill her obligations. Your Honor, the failure of the contract's successful execution lies solely with the counterclaimants due to their inability to ensure safety and completion of the services promised. Thus, Your Honor, the client is not liable for breach of contract, and any claims against her on these grounds should be dismissed. Thank you, Your Honor.
All right, please. Rebuttal from the counsel.
Thank you, Your Honor. Your Honor, regarding the arguments made by the counsel for the claimant, the counsel for the defendant submits the following rebuttals. The counsel for the claimant argued that there were many There were many points where the claimant fulfilled her duties. We do not dispute this, nor was this the basis of our counterclaim. We are claiming for the non-disclosure of the medical conditions as per clause 5.2, where there was a non-disclosure of her medical condition, and 5.3 for any new conditions that were followed after the main medical evaluation. Therefore, we have not disputed regarding any payment or anything else. Secondly, the counsel for the claimant disputes that due to unforeseeable reasons that were beyond control, that is frustration, the claimant must be excused. The non-performance once again was the non-disclosure and nothing else. There was no force majeure that prevented her from disclosing the headaches during all the months prior to the flight. She had many opportunities such as the declaration form, medical log, many meetings with the medical professionals, quarantines, etc. She did not take those opportunities. Had she disclosed her chronic headaches at any time prior to the flight, the spread of the virus could have been controlled or avoided and the flight would have been rescheduled instead of being cancelled halfway through the retreat. This would have been avoided. Therefore, the discussion of frustration is irrelevant and there was nothing preventing Ms. Astrothia from disclosing her medical condition. Thirdly, the counsel for the claimant argues that the claimant was not aware of her headaches, that it was not, I'm sorry, let me reword that she was not aware her headaches were a serious medical condition. The contract, clause 5.2, requires her to mention symptoms of a potential medical condition that may affect her fitness to participate in the spaceflight. While it could be a temporary ache for a normal person, for her it was a chronic headache, which she knew could hinder her opportunity to participate in the flight. As a result, she chose to withhold information about her condition. The fact that it is a required condition it is a normal and acceptable required condition to disclose a medical condition, that since it is normal and acceptable, she does not have to hide it with therefore, it is not up to her to decide what's important, but the doctors and the contract which demanded her that she disclose everything. Furthermore, the counsel for the claimant also claims that the damage was remote and trivial. The damage is surely not remote, as the lack of disclosure will make participation difficult. Everyone was aware of the COVID variant, and everyone knows how infectious it is, and how worldwide regulations are extremely strict about containing the spread. Of course, the spread of the disease on the spaceflight is cause for the return of the flight because people were getting sick. There are no hospitals or any other medical professionals available at that point. Therefore, this return has caused so much loss, and they still did it for the health and safety of all the crews and the passengers. This further shows that my client has the best interest of all the passengers at the forefront of their decisions at all times. Your Honor, this concludes the rebuttals from the counsel for the defendant.
All right. Sure rebuttal from the other counsel. Please, could you proceed? Any sure rebuttals? Are there any sure rebuttals from counsel? Are you there? My brother judges, please, what may we do at this point?
I believe we can wait for a few minutes to give her the right to defense as the claimant. She has to has the final words, but let us see what will happen with her because I think she has big troubleshoots.
All right, thank you very much.
Your Honors, can you hear me, Your Honors?
Yes, we can hear you.
Your Honors, can you hear me, Your Honors? May I proceed, Your Honors?
Yes, if you can hear me, please proceed.
Your Honors, do I have permission to start my restore rebuttals?
Please proceed.
Your Honors, I'm sorry for the break in transmission as I just keep on getting logged out from the site.
Yeah, I
Your Honors,
see.
do I have permission to start my sorry rebuttals?
Yes, please proceed. Can you hear me?
Yes, Your Honors. Your
Please
Honors,
proceed.
thank you. Your Honors, the counterclaimants argued that the defendants failed to disclose her headaches, which was a breach of the contract. However, Your Honors, clause 5.2 of the agreement stated that stated as specified conditions that may hinder my client's ability to participate in the space flight. Your Honors, my client's headaches did not seem to hinder her from passing the initial and subsequent tests. And she has lived with these headaches for the past 5 years in support of the belief that she was under no duty to disclose what did not appear to be a condition. Your Honor, the counsel for the counterclaimants argued that our client's non-disclosure to the cancellation of the retreat caused the reputational loss suffered by the counterclaimant. However, Your Honor, it's a submission that the counterclaimant's deficient medical protocols, which led to the outbreak of the virus, was a direct cause of the cancellation of the retreat. Your Honors, in the case of Amira Seafoods International v. IDBI, Bank Limited, 2008, DIFC, CFI 027. The court stated that a party may not benefit from the breach of contract where he contributed to that breach. The counterclaimant did not have proper safety and medical protocols, therefore they breached the contract. We therefore urge this honorable court to dismiss the counterclaim and uphold our defense as our clients did not expressly breach any term of the contract. Thank you, Your Honor. Your Honors, can the court hear me?
All right, all right. Yes, can you hear
Yes, I
me?
can hear you. Yeah.
Yes, Your Honors.
All right, I think this concludes the round, the session between University of Calabar and the Middlesex University, Dubai. Uh, Once more, I want to appreciate counsel from both teams. It was a nice face-off. I'd like to defer proceeding to my learned judges if they have my learned brothers if they have something to add.
No, I just want to thank all the parties. I appreciate all your submissions and your efforts. Thank you.
I would second what Brenham and Mohammed Abdul Fatah has said. Brilliant work from both the teams, and kudos to the efforts and reference and citations which was provided during the year. Good work. Thank you, everyone. Thank you.
All right, I think we've come to the end. All right, so have a great day ahead. If you have a further round going on, I wish you the best and good luck.
Thank you, Your Honor.
Yes, I think my learned brothers, I think we may have a discussion now.
Yes.
Please, counsel, you may exit. Have our counsel left? Well, I think so. All
Yes.
right. So in terms of the scoring, how do we proceed, please?
Branham, here goes my suggestion. I have put a draft. I have put some observations as well. I can send it to you both, uh, and probably you can add up or sum up both of your scores, and finally one version can go out if that is agreeable.
All right. What about you, Mr. Mohammed?
Yes, I agree. I think we should deliberate here first before, sending our final conclusion. Um, but I believe there are still some councils, right?
I don't think there's any counsel here. Please, is there any counsel who is here? If you're a counselor here, please could you leave?
I doubt.
Okay.
I doubt.
All right.
No,
All
no.
right. Please.
I am not the council. I am from the tech team. Okay, so yeah.
The web
Perfect.
support
All
team.
right. All
Web
right. All
support.
right. Fine.
Yeah.
So I think we should deliberate here first about
Yes.
what do we think, and then we
Okay.
can agree on someone of us who shall submit the final score sheet.
All
Maybe
right. All right.
it may be you, Mr. Brana.
All right. I think the Mr. Raj. May I call you that, please?
Yes, that's fine.
All
That's
right. I
fine.
think you said you have a draft. Could you read it out so we hear? That's the scores for the different council.
I'm sending one version right away, and probably you can take that and you can update it. One second.
Okay. However, as an overall review, who do you think who are the winners for this round?
Well, I think the team from Middlesex Investing. Did you get what I said?
Yes,
Yes, I think the school for Middlesex University ordinarily should be the winner of this round.
yes, they were.
My reasons, yes,
Mm,
my reasons are anchored on the fact that they had a better presentation, they were more fluent, and in terms of application of the law to the facts, I'll give it to them.
yes, I agree with you, and I have also tried to ask some tricky questions regarding, a legal fact that um, there was really a breach from the defendant, that they didn't make or they didn't have the PCR tests. However, they tried their best to persuade us regarding this matter, which I believe it's the most important point or the key point in this case. So I believe they have also uh, have a good persuasion to us. Um, However, I believe also that the claimant, the senior claimant, have had a good performance also.
Yes, I do agree with you.
By the way, gentlemen, I have sent it to you. I hope you received
All
it.
right.
Yes, let me check, please. Yes, I have received it.
Please feel free to do any changes because I just wrote it while the discussions were happening. So I'm good for any edits, any corrections as well. Because I had like first 15-20 minutes, there was a lot of technical issues, logging out, logging in.
All right. I think I agree.
Sorry, I'm just reviewing now.
Okay. But can anyone hear me?
Yes, I can hear you.
Yes,
All
yes,
right. All right.
yeah.
I believe that in the defendant section, the column of the defendant, do you mean by SC the senior defendant and junior defendant, right? Or this is
Yes.
the draft from?
Senior counsel, junior counsel.
Yeah.
Okay. Okay, I believe I agree with you. So the results are fine with me.
All right. The results are fine with me too.
Okay, Brenham, then can you send that as a final confirmation to the Moot
All right.
team?
All right. Let me do that now. Just
Yeah.
wait. Let me do that. Once I do that, I will let everybody know. Then we can leave.
Okay.
Is
Okay.
that fine?
Yeah, yeah, should be fine. Actually, to be honest, in realistic sense, the defendant side, logically, there might be problems, but their facts, citations were all very strong during the course.
Yes, I agree with you. I agree with you, because I believe that while defending this case, I believe that the defendant isn't in the strong position.
Absolutely, yeah,
Yeah,
I
so they have good persuasive skills.
exactly,
Uh,
yeah,
yeah,
and
that's
I see a lot of good teamwork as well, between both.
yes, from both of them. Also, when I have asked them, I believe this is it was a hard question. I was trying to find how they would creatively respond to this question, because they were first
Agree. Yeah,
trying to avoid answering this point. They
I,
were talking briefly. They were talking
I
briefly
know
about
that.
this matter of the PCR. So I wanted to highlight it to see, because this is your problem, and you have to find solution for this matter.
Absolutely.
and they try to avoid. So in before a real court, this would be a
Yeah.
problem. So, but however, I see that they have good persuasive skills,
Yeah.
so they did their best to defend this possession.
Absolutely. Anyways, before disconnecting Benham and Mohammed, very very nice meeting you both. Pleasure connecting with you both in this platform. Although initially we had a lot of technical issues.
Yes, yes, yes. I'm happy to have judged this round with you two.
Yeah,
Yes, it was a
it,
good connection.
it was an honor. Thank you very much, guys. So, Mr. Pranam, will you submit
Yes, I'm
the
on
score
it.
sheet, right?
Yes, I'm on it. I'll be done.
Okay,
Yes, I'll be
okay,
done soon. Just hold.
perfect, perfect. Just confirming. Will you be able to attend the final rounds in the DIFC courts?
Ah, uh, I don't know yet. I don't know
Mm.
yet. It depends. I'm looking for email. I think. All right, all right, all right. Okay. I think I have sent it. You may check your mail. I think you receive it too.
Let me check.
Mm, okay, I think I sent it to just Mr. Rad. Let me send it as a. Please hold. Let me send it as a whole document.
ممكن تبص على الفكرة بسرعة اللي شايفها كويسة ممكن تبص عليها بسرعة عشان
Hi, good afternoon, everyone. If I'm from Team Webnyay, if I could just step in for a moment, Mr. Branham, the next round that you are also a judge on has begun. So I would request if we can, if you could join that link at the earliest.
عشان تقريبا هيروح يوقعها.
All right. Yes. Well, we just concluded here. I'll join soon.
All right, sure. Thank you.
All right. I have sent it. I've sent it. My fellow judge, you may check now.
Okay, no
All
issues.
right.
No problem. No problem.
I sent it to the DIFC. Yes.
Okay, perfect. Thank you.
Thank you.
Yeah. Good.
Thank you,
Goodbye.
Jen.
Thank you. Nice to meet you all. Bye.
حاولت أغير التاريخ